operating with impunity. That's what it's all about. That's what the philosophy of this law is largely concerned with. Is it sufficiently grave, and would an investigation serve the interests of justice? So the prosecutor of the ICC, Marino Campo, can go to Gaza and deal with the situation there under this Article 15 mandate if it fulfills this criteria. He can do the same in Iraq, he can do the same anywhere, and he started to go down this route as it became clear that no leadership people were being prosecuted in Kenya for the violence that was happening, i.e. no politicians, no generals, no chiefs of police, because the magic word genocide had been used, that kind of thing. Principle of complementarity that I referred to, this is part of the ICC statute. There's a preamble, can't remember, I think there are 13 principles in this preamble, and one of them is that of complementarity, emphasizing that the International Criminal Court established under this statute shall be complementary to national criminal jurisdictions. International law respects national sovereignty, and that's where it should take place first in relation to criminal justice. If that fails, and a state is unwilling, as we looked in the previous slate under Article 17(1)(a), then the ICC can come in to see if it's appropriate to exercise its jurisdiction. In fact, I've got it on this slate here as well. So complementarity, fundamental bedrock principle, and first stop in relation to international justice. The issues of admissibility in relation to complementarity require a case to be investigated, prosecuted by a state which has jurisdiction over it, unless the state is unwilling or unable genuinely to carry out the investigation or prosecution. So there's an assessment by the ICC as to whether any trials taking place in relation to a situation that is within the jurisdiction of the court, so crimes against humanity, war crimes, genocide, whether that is genuine. Sham prosecutions don't serve. Prosecuting people, letting them out the back door, don't serve. It has to be assessed, and they take reports from Human Rights Watch, Amnesty International, Helsinki Watch, to assess the genuineness of what is happening. The case has been investigated by a state which has jurisdiction, and the state has decided not to prosecute the person concerned unless the decision resulted from the unwillingness or inability of the state genuinely to prosecute. So if a state investigates and thinks no evidence here, no grounds to prefer charges, and that is genuine, then that has to be respected. As I said earlier today, though, the ICC in the Katanga case, they actually stretched this definition alarmingly. Or the person ne bis in idem principle we looked at in relation to the Lebanon tribunal, and that someone has already been tried. And the ICC considers the particular process that the state applies, its systems. There was whether there is a shielding of perpetrators, so sham trials, that kind of thing. The ICC will consider whether there's been too much delay in relation to prosecuting proceedings. Kenya was starting to be looked at in the February of 2008 when Kofi Annan was sent as an emissary there. round to 2009 March, nothing significant in the views of the ICC prosecutor had happened, and so it was decided there was no genuine attempt to try and prosecute people it believed, before it had done an investigation, was the responsibility of the leadership. So that there are severe difficulties, in my view, in the tests that are being applied here, and you really do get down to the level of political fixers. Whether proceedings are being conducted independently or impartially, or inconsistent with an intent to bring the person to justice. And the court considers whether justice is possible in that state, and the judicial state, the system, the state is unable to obtain the accused or the necessary evidence and testimony, or otherwise unable to carry out its proceedings. So if someone's fled the jurisdiction, then that won't be held against the state. Now, at the ICC you have a trial chamber, appellate chamber, and a pre-trial chamber. When a case comes in, or a potential case, like the request for an investigation in respect of Kenya, it goes to pre-trial judges. And the pre-trial chamber examine the request of the prosecutor, the supporting material, and considers whether there is a reasonable basis to give permission to the prosecutor to advance his inquiries into an investigation, and whether those particular matters he's investigating are within the jurisdiction of the court. Now, the jurisdiction of the court set out in Article 7, I've already referred to them. But the Kenyan situation isn't a genocide. It's not war crimes. It's an internal conflict. So it comes within crimes against humanity. And that's what crimes against humanity can be, as one feature, are internal conflict within a state, and it has the substantive offences, many of which we're familiar with. Murder, extermination we don't have, but that's an international crime. That's the intent in relation to big murders, enslavement, etc., and other sexual offences. So that's their jurisdiction, and they've got to say whether those crimes in Kenya fell into any of those categories there. Further offences, persecution in a way that we don't have it in our jurisdiction, disappearance of persons, included as the crime of apartheid, and inhumane acts of a similar character. These are all the international perspective of criminal liability. Now, a crime against humanity, to be able to be charged, has a specific definition. An attack directed against any civilian population. So not two sets of armed forces. It's got to be against civvies. Involving the multiple commission of acts referred to in paragraph 1. So multiple enslavement, multiple extermination, multiple sex, multiple murders, all that lexicon of crimes, multiple in form. Now, this is a very interesting part here. Pursuant to or in furtherance of a state or organisational policy to commit such attack. So riots on the streets by loads of yobs don't come into that, because there needs to be an organisational element. Groups going wild in villages, setting them fire, fighting each other, spontaneous violence without a plan, essentially. So no state or organisational policy, and that's the phrase that is of concern here. State policy, we imagine the pogroms of the Nazi state. State policy, we imagine the pogroms of Karadzic with ethnic cleansing in Bosnia. Pogroms, we imagine the Hutus attacking Tutsis as part of their genocide occurring in Rwanda. Organisational policy, though, a different phrase and one we're not familiar with, but it must be part of that, have a policy to commit such an attack. Random acts of violence, no. Now, there was a split decision over the Article 15 request by the prosecutor in relation to his request for an investigation. And the majority decision, which was 2 of the judges in the pre-trial chamber, in relation to attack directed against any civilian population, their judgment was the first test to be considered is a campaign or operation carried out against the civilian population, i.e. not a military operation, but it can be a campaign or an operation. But the civilian population must be the primary object of the attack in question. So not giving attack a military expression. When you deal with war crimes, the order for attack is what the commander issues in a document to all the generals. It goes out, order of attack, and the whole circumstances of deployment of forces, from the catering corps down to the, or up to the infantry brigades, are all set out in what's called an order of attack. So attack carries with it a particular expression in military law. They say no, it doesn't have that military phrase here. It can be an operation or a campaign and have a civilian context as well. There were acts within the Kenyan situation of murder, rape, forcible transfer of population on the Kenyan territory that would fit the bill for that. Business premises were targeted, and residential houses, areas burnt down, and places where people had sought refuge. So taking the battle, not just amongst groups, but taking it to where people had sought refuge, indicates that this was being a target being made on a civilian population to attack them. State or organised policy, organisational policy. The majority in the court found that the second test to be applied, there is no requirement for an organisation to be state-like. What is relevant is whether a group has a capability to perform acts which infringe basic human values. Perform acts which infringe basic human values, and whether it is a group that has a capability.